In a shocking turn of events, Bryan Kohberger, the man accused of savagely killing 4 University of Idaho students in cold blood, has just decided to plead guilty after a 3-year legal saga, right on the eve of trial. Why do this now, and especially after he tried to point the finger at others? We're going to break it down. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Bryan Kohberger plans to plead guilty. That is a shocking headline that was first reported by News Nation. Came out Monday night. Still reeling from this, trying to understand why now. I think there is an important legal consideration, an important legal reason, something that just happened that may have influenced this decision. But I mean, for us here on Sidebar, anybody who's been following our show for the past, 3 years, we were covering this case even before we knew about Bryan Kohberger. We were covering this when the killings happened, and there was that whole 6-week search for the killer before his arrest. And when I say killings, you know what I'm talking about, right? The brutal stabbing deaths of 4 University of Idaho students at this off-campus rental home. 21-year-old Madison Mogan, 21-year-old Kaye Gonsalves, 20-year-old Xana Kernodle, and 20-year-old Ethan Chapin. This was back on November 13th, 2022. Now, 30-year-old Bryan Kohberger, who was arrested the following month, a former criminology student at Washington State University, he has been facing 4 counts of murder and burglary. And now it was announced on the eve of his criminal trial, about to begin in August. August 4th was jury selection, August 18th opening statements. He intends to plead guilty as per a plea deal with the prosecution in Moscow. And as part of that deal, the idea would be that he would be sentenced to life in prison without the possibility of parole, but the death penalty would be taken off the table. He'll also reportedly waive his right to an appeal. Now, as reported by the Idaho Statesman, according to a letter that was sent to a victim's family, Latah County prosecuting attorney Bill Thompson said, "We cannot fathom the toll that this case has taken on your family, and this resolution is our sincere attempt to seek justice for your family. This agreement ensures that the defendant will be convicted, will spend the rest of his life in prison, and will not be able to put you and the other families through the uncertainty of decades of post-conviction appeals." Here's the problem with that. It appears that some of the families don't want this. In a Facebook statement, the family of Kaye Gonsalves said, "It's true, we are beyond furious at the state of Idaho. They have failed us. Please give us some time. This was very unexpected. We appreciate all your love and support. Hashtag heartbroken. Hashtag Kaylee Jade forever." Now, in a follow-up statement, the family said the following: "The death penalty is merely an illusion in the criminal justice system. When available, it serves as a bargaining tool for the state, and when rarely applied, it's never enforced due to a highly inefficient appellate process. The notion that someone can plead guilty to a crime and still face years of appellate delays reveals a systemic failure. The Latah County Prosecutor's Office treatment of our family during this process is something I wouldn't wish on anyone. We questioned decisions early in the investigation. Why was the mayor commenting on the case? Why was the coroner speaking to families? Why was an officer with less than 2 years' experience leading the investigation? Why was the University of Idaho involved when they declared it an isolated off-campus incident? Why was the university permitted to write a book about the incident while others were silenced under an overly broad order? As a result, we were branded adversaries. So it was no shock how the Latah County Prosecutor's Office mishandled the plea deal. They vaguely mentioned a possible plea on Friday without seeking our input and presented the plea on Sunday. Latah County should be ashamed of its prosecutor's office. 4 wonderful young people lost their lives, yet the victims' families were treated as opponents from the outset. We weren't even called about the plea. We received an email with a letter attached. That's how Latah County's prosecutor's office treats murder victims' families. Adding insult to injury, they're rushing the plea, giving families just 1 day to coordinate and appear at the courthouse for a plea on July 2nd. Who do they think they are? After more than 2 years, this is how it concludes, with a secretive deal and a hurried effort to close the case without any input from the victims' families on the plea's details? Our family is frustrated right now, and that will subside, and we will come together as always and deal with the reality that we face moving forward. Once again, we thank everyone for their thoughts and prayers. Now, according to TMZ, Xana's aunt, Kim Kernodle, is furious, wanted Kohberger to face a jury, despite the prosecution allegedly telling them that this spares the families having to see gruesome crime scene photos, Kim responded, "We know the graphics. They were not trying to spare us." She claims when prosecutors informed them of the deal, they didn't mention removing the death penalty. Hey everybody, this is another Law and Crime legal alert. If you received Depo-Provera birth control shots and were later diagnosed with a brain or spinal tumor called meningioma, you may be eligible for a lawsuit. That's right, Morgan & Morgan, they're investigating claims that patients weren't properly warned about this risk. It's free to check, just takes a few minutes, and you don't pay unless they win. So scan the QR code on screen, click the link below, or go to forthepeople.com/LCDepo to see if you qualify. So now we have this hearing that's scheduled Wednesday. It is expected Bryan Kohberger will change his plea to guilty. This is a hearing that is required under Idaho law. So why do this? Why do this now? For that, let me bring on somebody who's been following the case from the very beginning. I'm joined by trial attorney, friend of the show, Rich Schoenstein. Rich, good to see you. Thanks for taking the time.
Happy to be here, Jesse.
Reaction?
Well, I'm shocked like everybody else. I didn't see this coming. Everything we heard about this case was that Bryan Kohberger was going to deny guilt and that the state of Idaho was going to vigorously pursue this prosecution. So I didn't know this was coming. I didn't have any preview, and I was very surprised that it happened.
What is your reaction to the family's reaction? I mean, the Gonsalves family attorney, Shannon Gray, told CNN the issue is they're trying to cram the plea for July 2nd, only gives the families a day to get to Boise. That's, aside from the scheduling of it, the lack of information, the lack of input. Does that seem typical to you?
Well, I have concerns about what we've heard, but also I think I'm right here. We've only heard from 2 of the 4 families. And one of the complicating factors in this is that there are 4 families that would have to be separately consulted and that might not all be of the same opinion. So I am concerned about what I've heard. If the families weren't consulted or they weren't given very much time in the course of being consulted or they haven't been listened to at all, I would be concerned about that. But I sort of suspect that's not really the case. I assume there was some consultation here. I assume there's been ongoing discussions with these families. I would have to know more about that back and forth to really have an opinion about it.
If there was, we don't really know the specifics of what was said and what wasn't. But if the family or families really do not want this to happen, under Idaho law, I don't know if you know this, could the court reject the plea? Could the court generally reject the plea if the families say, we do not want this? Or at the end of the day, if the defendant is choosing to plead guilty and the prosecution is accepting that, do the families really not have any input?
So I don't know the specifics about Idaho law on this point, but as a general matter, I would say that if you have prosecutors who have negotiated a deal and a defendant who is going to take the deal, and the deal appears somewhat reasonable, and he's agreeing to life in prison without the possibility of parole, the court's not going to deny that deal. The court is going to approve that deal, even if some of the families disagree. I mean, the court can't make the prosecutors seek the death penalty, which is basically the option here. So I think at the end of the day, the court will approve this deal one way or the other.
I am curious at this hearing, which we plan to cover, by the way, on Law and Crime. We're going to try to do live coverage. I'm curious if the family makes a statement, if they try to persuade the judge not to agree to this in some way.
Yeah, well, it sounds like at least 1 or 2 of the families are pretty vocal. So I expect they would try to be heard at this hearing and would try to be heard publicly. So I think that will be interesting. And I feel really bad for the families. You want them to have some level of catharsis here. You want them to get some solace out of the conclusion of these criminal proceedings. And it's one thing not to like the result. That may or may not happen, but to be so troubled by the process, I really feel bad for those families.
I want to go through maybe the legal reasons why this is happening, okay? So it was reported just days ago, before this plea deal, just days ago, that the judge overseeing this case, Stephen Hippler, who's going to be, ultimately deciding whether to accept this deal, barred the defense, prevented the defense from moving forward with a, quote, alternate perpetrator defense, meaning someone else did it. So apparently, while the defense intended to point the finger at 4 alternative suspects. Their identities unknown because there are sealed documents, although USA Today reports that there were 3 who were, quote, socially connected to one or more of the victims, while the other had a, quote, passing connection. The judge wasn't convinced. The judge wasn't convinced there was anything to back this up, saying, quote, the evidence is entirely irrelevant, citing a lack of motive or even means to carry out the killings. Hippler, writing in his decision, they have each cooperated with law enforcement, providing DNA samples, fingerprints, and allowing searches as requested. Notably, lab testing has excluded their DNA from samples taken from the crime scene and victims. And he went on to say it is not sufficient for a defendant to merely offer up unsupported speculation that another person may have committed the crime, which is all defendant has done here, and that this would, quote, lead the jury astray. Rich, I wonder, I gotta believe the fact that they weren't given this option, this defense, may have played a role in his decision to ultimately plead guilty.
Sure, I bet it did. When you think about it, the primary reason a defendant would agree to this deal is that he doesn't believe he has a chance of victory at trial. The evidence is overwhelming against him. I mean, from what I've heard, it's very compelling. He doesn't have a defense. He doesn't have an alibi. The court's not going to let him put in this third-party culprit kind of defense. So he feels going into the trial that he doesn't have any chance of success on guilt. And then he realizes that if I'm found guilty, they're going to consider the death penalty and they're going to find aggravating factors and I'm going to get sentenced to death. That is the most likely outcome if the trial goes forward.
Rich, I got to tell you, when I heard this is the first thing that came to my mind. Assuming he did this, right? What do I mean by that? Assuming he's not a guy who says, I'm completely innocent, but you know, I can't get a fair shake at this trial. I'm just, taking the best that I can. I don't want the death penalty. I'm pleading guilty to something I didn't do. Assuming that's not the case, okay? Let's assume he really did do this, okay? What a monster. What a monster for a guy who's admitting, who's going to plead guilty, okay? So if we're assuming he did this, he was trying to blame other people 5 minutes ago? I'm sorry, I know that you're entitled to a defense, but there's something about that that really, really gets me angry.
Yeah, I get that. I mean, he's going to go down as one of the great monsters in U.S. history. I mean, for somebody to come in to the home of these college students and do that to completely innocent people for whatever warped, crazy reasons he did it, it really is unspeakable evil. And we've assumed from the evidence that he probably did it. He's now going to admit guilt. His name will live forever as an example of evil.
And I also have to wonder, one of the reasons why he might have pled guilty, there was another legal development, right? It was also the judge recently, a few days ago, denied the defense's bid to delay the trial. The argument was that they needed more time for discovery. They also made the argument that because of the extensive media coverage of the case, including this Dateline episode, it may have created a prejudicial effect, particularly on a jury. But Judge Hippler wrote in an order, quote, defendant has not made showing that there is good cause to continue the trial or that his substantial rights will be prejudiced by proceeding to trial as scheduled. And he also added, the longer the public is made to sit and wait for the facts to come out at trial, the more time there is for inflammatory, speculative stories, movies, and books to circulate, and more time for prior ones to be rebroadcast, purchased, viewed, and consumed by the public. Proceeding with trial as scheduled will likely avoid negative consequences from future publicity. Rich, again, it seems to me that had a factor, that must have had a factor as well.
Right. I think people keep asking, well, why did this happen now? And the reason is that the trial was approaching quickly. And it's not unusual for basically all kinds of court cases get into settlement discussions on the eve of trial, both criminal and civil cases. And so with trial approaching here and rulings not going in his favor and the evidence stacked against him, it might have been a moment where he realized, I'm just going to have to plead guilty to save my life because going through with this trial isn't going to work, and delaying this trial isn't going to work either.
And in my legal opinion, they had him dead to rights. Okay? Look, he was innocent until proven guilty, but what did they have? Prosecutors allege that Kohberger's DNA was found on a Kaye knife sheath that was left at the crime scene. Cell phone records allegedly placed him near the victim's home before the killings, more particularly per reporting from Fox News and East Idaho News. We're talking cell phone data that demonstrates, or arguably demonstrates, that Kohberger's phone pinged almost a dozen times near a tower that provides coverage within feet of the crime scene. Surveillance footage apparently shows a white Hyundai Elantra matching Kohberger's car speeding away afterward. It was in that area multiple times too, according to the government. A potential eyewitness ID from a surviving roommate. Court documents indicate the roommate described the intruder as, quote, not very muscular, but athletically built with bushy eyebrows. And we did this whole separate sidebar on this as well, where there's this apparently, or maybe, a mysterious other witness, potential DoorDash delivery driver who allegedly saw Kohberger at the crime scene. Internet searches allegedly from Kohberger's phone about Ted Bundy, the Moscow killings, pornography. So again, what was the defense going to be, Rich? He was driving around late at night. You know, it was reported that the judge was going to allow the defense to call several people. One was apparently a friend of Kohberger's in high school. Another was potentially Kohberger's boxing coach, a guy who owns the dealership where Kohberger's parents bought the Hyundai Elantra. But when you look at that mountain of evidence, and I've been using that phrase from the very beginning, a mountain of evidence, it became very difficult for the defense to argue against it.
Yeah, I think it was overwhelming. But also, you know, Jesse, we can talk for a minute if you want about why the state of Idaho would do this. I know the evidence seemed overwhelming against him, but at the end of the day, there's a jury of 12 people, and they all have to be convinced beyond a reasonable doubt that the government has proved guilt. And so for the government, there's always a chance that somebody on that jury doesn't feel like they can convict this person. And so for them to get a guilty plea, first of all, it gets rid of the cost and effort of doing this trial, and it gets certainty.
Because it's expensive. It's expensive. It's not a trial. It's also a death penalty trial.
Right, exactly right. And it's not just a trial. In these kind of cases, it's years and years of appeals and habeas petitions and fights about the death penalty. And you avoid all of that. You avoid the public spectacle. You avoid shining a light on these innocent college students that were murdered in their home. You avoid the circus atmosphere. You avoid all of it. And you put this monster in jail for the rest of his life. And I do feel bad if one or more of the families are unhappy with that outcome, but I got to tell you, that is a good outcome from the prosecution's point of view. Life in prison without the chance of parole, not having to do a trial, not going through years and years of appeals, that is a good outcome for the state of Idaho.
And look, a jury would be spared from seeing these photos, even though the family said that they've already seen everything and they've already seen the graphics. They too were spared from seeing it. You also talk about the fact that maybe the surviving roommate doesn't have to testify and recount what she saw because she became a point of conversation as well. And you know, this trial would be difficult for a number of different reasons. Having said that, you can't put aside how the family feels and what they wanted and what they saw as justice. I guess my question is about this now. Are we ever going to find out what really happened here? You know, one of the interests that people had about this trial was, it wasn't necessarily was he going to be found guilty or not. I think a lot of people felt that he was going to be found guilty. And the question was, is any information going to come out, Rich, about why he did this, his motive, any kind of the why? And now that he is going to be potentially pleading guilty, I don't think by law he has to, there's a mandatory, it's mandatory that he provide a statement about why he did it. He doesn't have to do that. There's an Idaho Criminal Rule 33 that says before imposing sentence, the court must give counsel an opportunity to speak on behalf of the defendant and must ask the defendant personally if the defendant wishes to make a statement and to present, any information in mitigation of punishment. But are we going to find out any information from Bryan Kohberger? Are we going to find out any information from the prosecution now? You tell me.
So he's not going to be required to make a statement. I've never seen that in this kind of plea deal, to explain himself and say why he committed the crime. I don't think that's going to be required of him. He might get the opportunity to do it. He might get the opportunity to make a statement, or he can make a statement from jail. I mean, he can be interviewed. He can provide information if he wants, but he's not going to be obligated to. And we may never know really what the story was. The prosecution has evidence. They may be able to release some of that following the guilty plea, following the conclusion of the proceeding. Maybe we'll get a little more of the evidence that we would have seen in trial. You might get some more information, but are we ever going to really know? I mean, I don't think it's knowable how somebody could do something like this. I'll never get a satisfactory answer.
I'm hoping, because if they remove the gag order, because so much of this has been in secret, if we know, what his activity was leading up, the months, the weeks leading up to this, what was his search history, what was his connection? The stranger coming into the house in the middle of the night is what makes this particularly chilling and eerie. And that's the part that's very hard to grasp. And that's the part that I'm hoping everybody gets a little bit more information, particularly the families. The families need more information than anybody else. Now, one thing I wanted to ask you about is ABC News is reporting that the state will also seek restitution for the victims and their families. This is according to the plea agreement. What does that look like exactly?
Well, I mean, it's usually some sort of financial provision by the defendant. I don't know. I have no information about his financial wherewithal. I don't know what his assets are like. But if he has any assets, they could be significantly depleted in favor of the families. I'm sure that's not really solace to them either.
No, the University of Idaho released a statement too. We keep the families of the victims in our hearts as each deals with this outcome in their own way. No outcome can replace what they lost. We will never forget the 4 incredible lives taken. Rich Schoenstein, thank you so much. Appreciate you taking the time, sir.
Glad to be here. Happy 4th.
And that's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.